Hello, good evening, friends. I'm Dr. Amina Halima. We are going to see today interaction session on professional ethics and contempt of court. So let us start with understanding what do we mean by professional ethics and contempt of court. So let us bifurcate professional ethics. Professional means training for your livelihood. Ethics means human behavior. And when we talk about morals are the standard sets of human behavior. And when we talk about professional ethics in advocacy, it is strictly adhere with the advocates' conduct with bar bench relations and their duties, their responsibilities, and liabilities. So, majorly, we are going to see the two acts which will explain the provisions relating to our professional ethics. First of all, Advocates Act 1961 and the Contempt of Court Act 1971. So, friends, let us understand the professional ethics. First of all, we are going to see the scope of this professional ethics, which is strictly towards the court. It extends its applicability is with the court and bar bench relations. Bar means advocate, bench means court. And when it comes to advocacy, it's a noble profession. It's serving to mankind. So we do understand that the extent of this profession is very vast. Now, when we talk about the legal context, the importance of ethics in maintaining integrity of legal profession, it is always advocate by its conduct. So, core ethical principles, which is relating to the relationship, a professional, healthy relationship with the client, towards colleague, that is brotherhood, fraternity, and of course, dignified and self discipline towards court. The competency includes the decency in court of law. Then we are going to see some conflict of interest, duty to the court and the client. When we talk about duties, it is mentioned in the rules given by the statute. We are going to discuss couple of case laws when it comes to professional ethics. So, couple of case studies. Uh, for example, we see Rangadurai versus D. Gopalan and others 1979. Let us see what was the fact of the case. So, advocate was accused of professional misconduct for misappropriation of clients' funds. And obviously, there was a verdict given by the Apex Court of India, the Supreme Court, imposed strict penalties and emphasized the need for ethical conduct. So, significance the reinforcement of duty of lawyers to uphold professional ethics, demonstrate the consequences of violating ethical standards. We are going to go through some content of the role of Bar Council of India, that is BCI. It's a regulatory framework overview of Bar Council of India's role in regulating the legal profession, the key regulations relating to professional ethics, disciplinary actions, procedures for addressing violations of professional ethics, case examples of disciplinary actions taken by the Bar Council of India. In another case law, DP Gupta versus Ram Murthy and others, 1997. The fact of the case was about advocate disbarred for tampering with court documents. The judgment was given by Supreme Court, ruled in favor of strict action to preserve the sanctity of legal profession. So the highlights of the gravity of ethical violations and the judiciary's role in enforcing standards. My friends, dear friends, try and understand when we talk about professional ethics, it is related to your behavior. How do you behave in court of law? How do you behave towards your client, towards court, towards your colleagues? It's everything is given in rules given by the BCI. It is not only your attire you're wearing, your band, your uniform. It is overall code of conduct. And when we talk about contempt of court, so contempt is again defined in Act of 1971. So basically, it is bifurcated into two forms of contempt. First is civil, that is willful disobedience of court orders. It may be judgment, it may be decree. And when it comes to criminal contempt, the acts that lower the authority of the court and interfere with the judicial process, that is criminal contempt. Both is of severe nature. There is punishment, there is reprimand, there is warning, there may be suspension. So please be careful. Legal provisions for the contempt is given under the Court of Contempt of Courts Act 1971. The power of the High Courts and the Supreme Court given under the Constitution. As we know that High Court and Supreme Court is a constitution body. It is given under the Constitution of India 1970. Let me discuss the case law of Prashant Bhushan, contempt case 2020. So, the fact of the case was senior advocate Prashant Bhushan was held in contempt for tweets critical of the judiciary. Please try and understand freedom of speech and expression is given under fundamental rights. That's part 3 of Constitution of India. To be precise, in Article 19, Clause 1, freedom of speech and expression. But please do remember that these restrictions, these rights, fundamental rights, are with some certain restrictions given under Article 19, Clause 2 to 6. There are 8 to 10 restrictions, which we will discuss in later part. First, try and understand this famous contempt case of Prashant Bhushan in the year 2020, which was for the tweet critical of the judiciary. Judgment given by the apex court convicted him for critical contempt, criminal contempt. So, discussion on the balance between freedom of speech and respect for judicial authority, implication for the legal community, and public disclosure. So, fine line for navigating the ethics versus contempt. To be precise, balancing professional responsibilities, how lawyers must navigate ethical duties while avoiding contempt, the role of advocacy in ensuring justice without overstepping legal boundaries. The case example Arundhati Roy, contempt case of 2002. Overview of the case where the author Arundhati Roy was found guilty of contempt for statements against the judiciary. Analysis of the court's rationale and its important impact on public criticism of the judiciary. So thank you very much, students. We'll see in some other lecture. Thank you. Take care. Bye bye.